Okay, it's loading on YouTube right now, and okay, we're good to go, Rich.
All right, thanks, Kim.
Okay.
Afternoon, everyone. It's a little after 4. Thanks for bearing with us. This is a class on the RPA. I haven't taught.
Okay, we're good to go, Rich.
All right, thanks, Kim. Afternoon, everyone. I'm hearing feedback. Where am I hearing feedback from? I'm hearing myself.
Okay, we're good to go, Rich.
Thanks, Kim. Where is that coming from? I'm hearing feedback. We got it?
I think so.
Okay. All right. All right. So it's on the RPA. Haven't taught the RPA in a while. So I want to give, if for those of you who don't know about this, I want to give you a little trick for your clients, either be a buyer or a seller. I am going to share my screen and let's see here. All right, what you should be seeing is ZipForm. So if you, not actually the ZipForms, but if the homepage of CAR.org, if you go down, pull down Transactions Center, there is a tab that says Forms Advisor and Forms Tutor. Does everybody see this page? Thumbs up? Yeah, I see heads up. Okay. All right. So if you go to Forms Tutor, access Forms Tutor, probably going to want my login again. No, it brought me right there. So it doesn't have all the forms, but it has some forms. If you want, it'll give you a little overview of what the form is, and it has these little blue buttons, and it tells you a little bit about the form. But that's not what I want to show you right now. I want to show you this thing that's right here, the Consumer RPA Summary. So what you do is you click on this and it will send this, a copy of the RPA to your clients. And I'm going to show it exactly what it's going to send to your clients. That gives them an overview of the RPA. It's great for new buyers that, you know, hey, this is what our offer is going to look like. If you have any questions about any part of it, it will explain it, or to the sellers, and you can send it to your sellers to say, hey, this is what the offer is going to look like when we get it. So you click here to put in your client's email address, and then let's see, I'm wanting to show you what you get. Hold on. Sorry. Here it is. You should see a little screenshot of an email that was sent, and it has a link, and then it has a password that's good. That's good to for your client up to 60 days to keep going back to that that link, and then one more time. It will. Hold on.
Rich, I can't see your screen.
I'm not sharing anything right now. I'm looking for what I want to share. Hold on. Where is this? Sorry. Where is it? I'm not seeing it. Let's just go, so we don't really waste any more time. Let's go right to the RPA. If I have a chance to go back to it and I find it, I will go. You should be seeing right now the RPA. Thumbs up if you see that. Got it. All right, so this is the RPA. There's a lot of forms that it bundled together before this, but we're gonna just go over the RPA because that usually takes up the whole amount of time. So very important, put in a date prepared, because this date is on subsequent forms moving forward. It's not the date that's signed. It's not, you know, any of that. It's the date that's prepared. So this is an offer from a buyer about a specific property, and give the details, the APN number. You need to find that APN number. If you're on the MLS, you can search the address through, well, the APN should be also on the MLS sheet. You can get it from there, or you can get it from Realist. There's a number of places you can get the APN number, but make sure it's on there so the property is identified correctly. Purchase price, all you have to do is put in a number and it automatically puts it in as types it out as words. So close of escrow. You can either do a close of escrow a number of days, or you can do it on a specific date. I had a client who would only qualify for a loan. She was a freelance in television production, and so she was only employed in 8-week increments. So we had to make sure that she was employed, because if they did a final verification that she was employed, the lender, so we put in a specific date. So that's where that comes in handy. This next portion is really important, the agency. Who's representing who? As we all know, agency is through the brokerage. So it is Keller Williams Calabasas or Keller Williams West Side, or whatever brokerage you're at. That is the firm with the firm number. Make sure the number's there. And then the agent, and make sure your DRE number's there. So if two different agents from Keller Williams West Side are are in this deal, it is a dual agency because the agency is with the brokerage. So that's important to note. So then we go down to financial terms. The initial deposit, we like to see 3% as an earnest money deposit. We'll talk a little bit more about that going forward, but you usually put 3%. Now in Northern California, they don't do 3%. They do like 1,000. They do 5,000. They do things differently. Different markets do things differently. And we want to leave this, as far as how the money is delivered, we want to leave it in the default, electronic funds. We don't want to touch a check. The minute we touch a check, it has to be logged into the trust log at the office. And then what happens to that check has to be documented. So we just don't want to touch a check. So make sure you just leave it as defaulted to electronic funds being sent to escrow, directly to escrow. And this is the only time frame in this whole agreement that is business days. They have 3 business days to get the offer, the earnest money deposit into escrow. 3 business days. What's a business day? Monday through Friday. Saturdays, Sundays, and holidays do not count. Business day is Monday through Friday. So there you go. Increased deposit. A lot of people are confused by increased deposit. Where would you use increased deposit? If somebody says, okay, I'll put $5,000 down as an earnest money deposit, and then I'll add and I'll increase the deposit once something happens, either in a week or after the seller delivers disclosures, that is increased deposit. So if liquidated damages are initial, then whatever that increased deposit is, it goes towards the liquidated damages. So just be aware that not many people use increased deposits anymore, but just in case you see it. 3C is an all cash offer. If it is all cash, then you check right there that 3C, and it automatically unchecks. It automatically checks that there is no loan contingency. So just so you know. And here is the if you have a loan, here is where you put in what those loans are, and please fill this in. Get this information from the lender. What is my client getting as far as an interest rate? If they're getting 3.5, then you may want to cap it at 3.75 or 4. If they're not paying any points, maybe you'll the buyer will proceed with the sale if they pay a half a point. What's a point? It's 1% of the loan amount. So if it's a $100,000 loan, then it's $1,000. So just make sure that this is filled out, because if it's not, then something screwy happens with interest rates between now and when your client gets approved for the loan while you're in escrow. They have to move forward. They have no parameters on that loan. So please include that. If it's an FHA loan, you indicate that it's an FHA loan, and it's automatically going to generate an admonitory clause. And a lot of people were confused by this clause in this market, where people were getting rid of their appraisal contingency, because in that clause, if it's an FHA loan, you cannot waive the appraisal. So that was something interesting that was happening. Additional financial terms in a market where it's a buyer's market, unlike what we have now, you can ask the seller to pay for closing costs. So that's where you would go with additional financial terms. I have an agent right now who is buying a property for her family, and she is crediting the buyer's agent commission back to the seller, and that money is being counted towards her down payment. So that's an example of what you would put in there. And all this is calculated, and all the numbers fill in as you fill it in. I see that there's did you say that you can't waive the appraisal on an FHA loan? Yes, you cannot. It is true. You cannot waive that appraisal. So yes, it's in that advisory, admonitory clause that generates after you choose an FHA loan. So just be aware of that. All right, so that's page 1. Any other questions on page 1? Let me see. No, I'm not seeing any. All right, so let's go to page 2. Top of page 2 is verification of down payment and closing costs. You're working with a buyer and say, well, I'll give it to them in 3 days. How far do you think that offer is going to get with a seller's agent? Not going to get very far. Even in a buyer's market, they want to see that you have the money before they accept an offer. So always be aware of that. Appraisal contingency. You can check this, that it is not a contingency. That's happened a lot. So this is where you would do it, that it is not a contingency. Loan applications, another example of, yeah, you're going to have to supply a letter going in, a pre-approval, not a pre-qualification. Excuse me, what's the difference? The difference is a pre-qualification is a loan officer has been given an idea of what you make, what your expenses are, and based on that information, based on that information, if I put the numbers together, they can qualify for a loan up to this amount. Pre-approval is that they've looked at the documents and they've seen all the documents, and based on what they've seen, then they approve up to this amount. So it pulls a bigger punch on pre-approval. And so if you're a listing agent, you want to see a pre-approval over a pre-qualification. So loan contingency removal. There's a check box or a box for whether there is a loan contingency. You can check that there is no loan contingency. Now, in this market where appraisals are being waived, but there still is a loan approval, there is a line here I want to point out. If there is an appraisal contingency, removal of loan contingency shall not be deemed removal of the appraisal contingency. But also, no, it's in J2. Okay, if there is no appraisal contingency, or the appraisal contingency has been waived or removed, then failure for the property to appraise at the purchase price does not entitle buyer to exercise the cancellation right pursuant to the loan contingency if the buyer is otherwise qualified for the specified loan. So what does that mean? If you've waived the appraisal contingency and it doesn't appraise, but you still could qualify for that loan based on everything else, you can't cancel because of the loan, because you still qualify for the loan. So you have to come up with that extra money in order to make the difference. Number 5, very important, lenders' limits on buyers' credits. So there are limits. If there is a loan, there are limits that the lender is going to allow to be credited. So if you have all these repairs that need to be done and you negotiate a credit, and the lender, this is why you need a good relationship with your lender, the lender will only approve part of that amount. The seller doesn't have to give a credit in excess of what is allowed by the lender. So guess who they're going to go after if they're not allowed that credit? They're going to go after you as the agent. So that's important to note. So once again, keep that relationship with your lender really good, because you need to know what the loan parameters your buyer is getting, and also how much of a credit that they will allow. Mona, you have your hand up.
Yes, I wanted to ask a question about the appraisal contingency. So obviously it's a really big trend that a lot of people are waiving their appraisal contingency, and it's most likely it's happened that the home is appraised for less than what they're purchasing because they're buying above market value, right?
Right.
Now my question is, have you seen a lot of people lose their deposit because they can't come up with the difference? Have you seen that trend?
Well, as the listing agent, you should be looking at what they have, and as far as reserves, knowing that they they should be able to make up that difference. Am I seeing, a lot of people losing deposits? I see disputes over deposits for other reasons right now. So, but not because of the appraisal. I mean, if you're representing a buyer, and they're removing the appraisal contingency, you need to have a real conversation and back it up in writing about what that means. If it doesn't appraise, the lender will still give you money, but they're going to only give you money based on the appraisal value. So if you're $20,000 short, that you have to come up with that 20,000. It's as simple as that. So,
Rich, can I ask a question as well?
Sure.
Same thing regarding the appraisal. As a listing agent, I am getting multiple offers from FHA buyers removing the appraisal contingency. So what am I supposed to do with that?
Contractually, they can't. Contractually, they can't remove that. If you read the FHA admonitory clause, read it. Because it basically, in that clause, it states that if it doesn't appraise, the buyer can back out. And that supersedes anything else. I mean, it can't be waived.
So basically, they're not liable. If it does, they can get out of the loan just from that.
Yes.
Yeah. Okay.
Yes, they can.
Okay.
Yes, they can. I wouldn't accept it as I wouldn't accept it because it's not enforceable. So, yeah. Number 4, sale of buyer's property. This says that I have to sell my property before I can buy yours, and it generates another form. FYI, my next class is on disclosures. If I have time, I'll go over those forms. They are confusing, I know. So that's number 4. Number 5, addenda and advisories. A lot of people add statewide buyer and seller advisory. If you are asking for any of the services that your particular office has an affiliation with, say the escrow company or the NHD company, if you're using my NHD, asking to use my NHD, you should be including the ABA disclosure. You should be including that disclosure that says, we as a company have an affiliation that may be beneficial to us. So you need to include that as part of the advisory or addendum. Other terms, if the buyer has a real estate license, this is where you would put it. You'd say principal has a valid real estate license. Other terms, if there's other tricky terms, you would write that in there also. NHD, you want it's customary for the seller to pay for the NHD. Also, check environmental. It's only a few bucks more, so check it, and you can specify a company if you want. And here is where I see, Moni, you saw the question, or is your hand still raised?
I did have another question. What if the buyer previously was a realtor, but they're not anymore and they're not active?
But is their license still, has their license expired or not? If it doesn't matter that they're practicing or that their license is under brokerage, it matters that they are licensed, and here is why. Because as a licensee, you have more knowledge about this transaction than the general buyer, and that needs to be disclosed. So if they have a valid license, doesn't mean that they have it under KW or wherever. It has to be disclosed. It's a code of ethics. It's a Code of
So if
Ethics.
your license is expired, you don't disclose it, but if it's active and not expired, then you disclose it regardless if they are using it.
Yes.
Thank you.
Yeah. And personally, I would disclose it if it was expired. The fact that you had a license, that you went through all these classes and obtained a real estate license gives you more knowledge about the transaction than anybody else. So I would still disclose it. It's not necessary. I mean, it's not mandatory at that point, but I still would disclose it. So I want to mention here where inspections, reports, and certifications. I see, please, everybody on this call, do not do this. Do not put termite in on this contract anywhere. Don't say seller to pay for a termite report and then to do section 1. Don't do it, because if it has a loan and you're trying to negotiate a credit instead of doing the work, the lender will not let you do it, because termite is a part of this agreement and they are going to want to see a clearance. So that means all the work has to be done before close of escrow. That means if there is a tenting recommended, then that house has to be tented before close of escrow. So don't do it. Don't include it. Also, don't include people buyer to pay for an inspection report. I've been seeing that a lot too. Don't do it. Why? Because if there's a loan on this and the buyer, it says here that the buyer is going to do an inspection, then the lender is going to say, hey, I want to see that. It's part of the agreement. Don't do it. All right. Governmental requirements and retrofit. So there are certain requirements, state requirements, that for safety reasons that have to be done before close of escrow. Smoke detectors, carbon monoxide detectors, all of that. Oh, going back to termite, listing agents, counter it out. Counter termite out. Termite is not a part of this agreement. Counter it out. But also listing agreements, listing agents, make sure that before the appraisal is done, that there's a carbon monoxide detector on that property. Carry a whole bunch with you, so that you have them. Is it, your name's not coming up? Charles, is it? You have your hand up?
Yeah. We typically will put like the home inspection report as something the buyer will pay for under like 7A2. Is that recommended?
No, don't do it. We know that the
Home
buyer
inspection.
has the right to do it for the reason that I just said, that if it's in the RPA, then the lender has the right to see it. And you don't want a lender to see an inspection report. You don't. So no, don't write it in the RPA. All right. So next, oh yes, carbon monoxide, water heating, bracing. Those are required by state. They're state required, but there are some areas like Los Angeles that requires somebody to come out and inspect. So we normally ask the seller to pay for those. Also in Los Angeles, there is the 9A report that is required before close of escrow. Guys, we don't, on advice of counsel, we do not waive that. Especially if a property, there will be very rare occasions where I will allow a waiver, and that's if the property is in such disrepair and it's going to be torn down and nobody lives there and nobody is going to live there. Otherwise, otherwise, I lost my train of thought. Sorry, because Aaron, I saw your question about, and I was trying to think: is there another way to ask the seller to pay for a termite report? It's $100. It really is. Here's the thing: do you want the seller choosing who's going to inspect that property? No, I don't want to rely on a report that was paid for and gotten by the seller about the seller's property. Termite, inspections and a general inspection and sewer inspections, they're part of the buyer's inspections. They're part of their due diligence. So the buyer should be paying for it, and the buyer should be choosing who does it. We make recommendations, but the buyer should be choosing who does these reports. So that answers that question. Okay. So also we were talking about 9A. Those are a governmental inspection and reports. Pasadena used to have homeowners before close of escrow, there would be an inspection and whatnot. They've made that process a little easier. In Long Beach, there is a garage ordinance that is about a specific area. Just be aware of what's around your specific area. So normally we ask the seller to pay for all of these requirements. Escrow and title. Buyer and seller, check both boxes. Each pay their own fees. Do not say 50-50 because escrow fees aren't 50-50. It's each pay their own. The buyer pays theirs, seller pays theirs. Title, we usually ask for title to be paid by the seller. And you can always, as the buyer's agent, request who you want to use. If you want a Pacific Coastline escrow, put it in. Maybe they know the escrow officer and they'll say, okay, sure, we'll give it a shot. So so don't think that it's always in the seller's hands. So on average, who pays more fees? The seller. Well, I mean, it all depends. The buyer has interest tacked on that if there's a loan, and property taxes and all that. It all depends. So other costs: county, city, HOA. If there is an HOA, we normally ask for the sellers. Private, I always check private transfer fee and then add if applicable. So I would do that. Home warranty. Get an amount. Always ask for upgraded. Choose your servicer, and choose what's being included. Because if it's not included in the contract, then it's not a free-for-all that you can spend all the money. But can you say how you like us to write into the agreement when the buyer pays up to X? That would probably, and where in the RPA? I would say that you would put it in other terms, and you would say that buyer to pay, should the property not appraise for value, buyer will pay X amount of dollars over appraised value. There's other language. Instead of figuring out here, there is a great CAR legal notes on, just go to car.org and then with a little magnifying glass, search for appraisal, search for appraisal. And I think they give you some great wording there. So, all right. So, okay, items included and excluded. Even though it says something in the MLS isn't this agreement. So you have to say what's included and what's excluded in this agreement. So if you want all stoves, all refrigerators, all washers and dryers, make that clear on the agreement. I had an agent, it was checked all refrigerators, and then the sellers, when they moved out before close of escrow, took the wine cooler that was portable, but it still is a refrigerator and it's included. So that agent then had to buy a wine refrigerator for that new buyer. So it needs to be clear, and it needs to be made clear to your clients. Listing agents, if they're excluding the chandelier that grandma gave them, tell them to remove it before it goes on the market, because inevitably the buyer who's going to buy that is in love with that chandelier and they just want it, and they, and it'll just cause problems. Leaned or leased or leaned items, very important. We need to know if there's solar panels or a water softener or whatever it is, whether it's leased or there's a lien on the property. Need to know about that. Exclusions. Also, really important here, brackets attached to walls, floors, ceilings for any such component, furniture, or item shall remain with the property, or if this is checked, will be removed, and holes will or other damage shall be repaired but not painted. This is important for TV brackets. These brackets are expensive, and seller may want to take it, and if they do, make sure that that's made clear to the buyer, or the buyer doesn't want it, and so they want it removed, and to patch up the holes. You don't have to paint it; you just have to patch it. Buyer intends or doesn't intend to occupy the property. That's important for the lender. And seller occupied. Look in the MLS, because possession, there is a line for possession, and some people say COE plus 2, COE plus whatever. And if they're asking to remain in the property, that agreement should be made here. We shouldn't deal with that afterwards, because inevitably it becomes a problem. So if they're staying even one day after close of escrow, it generates a form, and it's called the SIP, seller in possession. That's for days 1 through 29. Day 30 plus, it's a different form. It's RLAS, residential lease after sale. Why? Because that 30 days or more creates a tenant-landlord relationship. So you really want to keep it less than 30 days, because you don't want to create that relationship, because with that relationship comes some rights. So if at all possible, and lenders don't like it. They don't like anything over 29 days, to tell you the truth. So if, like I said, if seller's remaining in possession, it creates these forms. If it's tenant occupied, that has to be, if tenants remaining in possession, it's a TIP. Look at this contract, tenant occupied. If it's a tenant occupied property, and the tenant supposedly is not to be remaining in possession of the property after close of escrow, then the property shall be vacated at least 5 days prior to close of escrow. So I had something come up just the other day, and oh, they're going to move out on the 2nd, but we're supposed to close escrow on the 29th. I said, move the close of escrow. You want those people out, especially in what's going on now. You don't want a tenant in the property. If they're not supposed to be there, make sure that they're out. So that's all I can say. Statutory and other disclosures. Statutory disclosures, what does that mean? That means they are required by law. And what are they? Lead-based paint. If that property is built prior to 78, then there needs to be disclosed that there most likely is lead-based paint somewhere on that property. Another statutory requirement, the brand new one, if you're in a high or very high fire zone, you need to use that new form, which they haven't added to this, that new form about fire hardening and defensive space. So that form is required by statute. TDS, TDS is required by statute. A transfer disclosure statement. Now, if it's a probate or if it's a trust, but here's the caveat to the trust, it has to be a surviving trustee, meaning that the trust of the individual who is the trustee passed away and it moved to a surviving trustee who hasn't lived in the property. Maybe it's a child who lived in the property when they were, 15, but now they're in their 40s or 50s. They're a surviving trustee. They are exempt. So probate, surviving trustee, and bankruptcy, bank-owned, those are exempt from the TDS. If they're exempt from the TDS, they still have to do what's called an ESD, which is an exempt seller disclosure, which is that really shortened one, important question: has somebody died on the property in the last 3 years, amongst some other things. But those are required. If they're not exempt, it has to be done by law, and it needs to be filled out correctly. And part of the TDS is the agent's visual inspection, the AVID. So if you're a listing agent, that TDS isn't complete until your AVID is attached. So I know a lot of listing agents wait until the last minute in order to do that AVID. You should not be waiting. So you should be doing it at the beginning. You should be giving it with all your other disclosures, so that so just know that it's not complete. So these are statutory requirements. The NHD is also a statutory requirement. So that's really important to know. Somebody have a question? I heard some noise. No? Okay. What else? Moving on to, it mentions the natural hazards, withholding taxes. It's important to note that if that the buyer is responsible to send in the seller's taxes on the sale, unless the seller fills out a FERPTA, which is, says that they're either exempt or, whatever. But if you're dealing with a seller that is not from this country, then it's really important to note that the buyer is responsible to pay those taxes, to make sure those taxes are, so you want to make sure that that's done correctly. Moving forward, talks about Megan's Law, about gas pipelines. There's websites to look at all that. have to disclose, seller has to disclose whether this is a condominium or it's located in a planned development. There are single family homes that have an HOA under them. So it's important to note that. Condition of property. I love all these listing agents who put in a counter, property sold as is, but seller will not make any repairs, blah, 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 blah. Well, it's right in the RPA, right here, item number 11. It's property is sold as is and in present physical condition. Seller has an obligation to disclose material facts that may affect the property. The buyer can conduct their inspections, and whatnot. So, but it is, every property in the state of California is sold as is. So you can write all you want and it's sold as is, and it's just a waste of ink as far as I'm concerned. This talks about the buyer's investigation of the property. They're not allowed to bring in contractors and cause damage to the property, and the buyer indemnifies the seller, about should they enter the property and all that. Title investing, and I'm moving quite ahead, I'm sorry, but I can see when the new RPA comes out, I'm going to need more than an hour, because the class that I'm taking is 4 hours, and how to condense that, I'm not sure. So anyways, title investing. We never counsel a client on how to take vesting. They need to consult their own tax person. So that's really important to tell them. Here, item number 14, time periods and contingencies and all that. Seller has, by default, has 7 days to order reports, to do all of, give reports to the buyer. That's, the NHD report, the prelim, all of that. They have 7 days to do that in. If they give something after those 7 days, then the buyer has removed their contingencies about those disclosures, the buyer still has 5 days to either approve or cancel because of that, what they found out in that late report, let's just say. Okay, so buyer has 17 days default to do their investigations. Please let your clients know it's more than just the physical property that they're inspecting. It's the neighborhood. It's, it is whether you can get insurance. If you're in a high fire zone, it's not easy to get insurance. So all that has to happen within that time frame of what you've given for those inspections. So so it's more than just the property. Like I said, I said on a office meeting a few weeks ago, have your buyers knock on neighbors' doors, say, hey, how do you like the neighborhood? I'm thinking of buying, blah, 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 blah. Neighbors will tell you everything. They are a wealth of information. And this is the story, cautionary tale. My agent represented the seller, and it was close of escrow. They closed escrow. It was recording that day. Buyer took until that day to do their final verification of property. Walks up and was doing their inspections, and the neighbor walks up to the buyer's agent and said, oh, did the seller disclose to you that this was a grow house and it had been raided many, many times? It's like, no. Guess what? Seller didn't even tell the listing agent. So when the buyer found out about it, buyer says, I don't want to buy this house. I want to rescind the sale. Guess what? They rescinded the sale. They had every right to. So it's knock on those doors, ask the neighbors. because they are a wealth of information. So access, this is a little clause that not many people are aware of. You may have 7 days to do your inspections, but unless this number 5 is changed, that buyer still has 17 days to have access to that property. They want to have measurements, to do other inspections, or have contractors come in. They still have those days per the contract. So that's important to know. Removal of contingencies with offer. If the buyer is removing all contingency with the offer, they will attach a contingency removal, removing all contingencies. What else must that buyer sign? Every one of my offices, and I'll make sure if there's anybody from Larchmont out here, that Larchmont also has this. It's a non-contingent offer addendum, and it tells the buyer, you're making a non-contingent offer, but I don't recommend you doing this. And you're acting against the advice of broker. I never recommend giving an offer where there are no contingencies. It's basically, if you find out something's wrong with the house, or maybe there is something really seriously wrong with the house, you've just handed over your deposit to the seller, because they have every right to that deposit, because you removed all contingencies. So moving on, seller's right to cancel. Seller, that you tell the seller, you are stuck with this person. You're stuck with them. The buyer has all these contingencies to get out of this agreement, but the seller only has one way to cancel this agreement, and that's only if the buyer isn't performing. So if the buyer is performing all the way and the seller just, I hate this buyer, I don't want to sell to them. Guess what? As long as that buyer is performing, he can force you to sell it to him. If he wants to go through the expense of going through a specific performance and getting a lawyer and putting a lease penance on your property in order to force you to sell that house to him, he can do that. So it's really important to note to your seller, hey, you're stuck with him. But if he doesn't perform, you can cancel by giving them a notice to perform. And you give them a notice to perform, and if they don't perform within 2 days, it's not 24 hours, it's not 48 hours, it's 2 days. And so if you give it to them on 5 o'clock on a Tuesday, day 1 is Wednesday, day 2 is Thursday, and at midnight on Friday, you can cancel. So that's how that works. Can't end on a weekend or a holiday. So keep that in mind when giving a notice to perform, but you can, that's the only way a seller can cancel. Now, if the notice to buyer or seller to perform, and it's, you see there, it's at least 2 days. Now, there are some agents who will change that number. Be on the lookout, listing agents, for agents that are being tricky, trying to be tricky and say 5 days, because whatever is in the contract is sticks. I can't tell you how many agents have said, well, I want to give them a 1-day notice to perform. Well, what was in the contract? Well, it's was left at 2, and then you have to give them 2. But if you're a tricky agent, I'm representing the buyer, and you change that number to 10 or to 5 or whatever, and agents don't notice it, guess what? They have those days. Effects of buyer's removal of contingencies. Once you remove the contingency, you can never use that contingency to back out. If you remove the appraisal contingency, you can't go back and say, oh, I want to I changed my mind. Or if you remove the inspection contingency, you can't go back on that. Once you removed it, it's gone. Close of escrow. There is a close of escrow. There is a date. So things happen. That date may move. Protect your clients, and when that date is moving, move that date through with the contract. Do an extension of time. I can't tell you how many times that we were supposed to close 3 weeks ago. Well, did you move the close of escrow date? You're out of contract. Everybody's in default of contract. Move that date using the extension of time addendum. Mona, you have your hand up.
Yes, I have two questions. So we all know that contingencies help you get out of the escrow and still keep your deposit. But if all the contingencies, the appraisal, the inspection, the loan, the seller disclosure, if all of those are waived, does the buyer have any other right to get out of the contract?
No, he doesn't.
So they can't just change their mind for no reason and say,
No.
oh, I changed my mind, I get cold feet.
Nope.
Okay. The second.
Well, you can get out of the contract, but you give up your deposit.
Okay. And then the second thing I wanted to ask you is, I know when somebody was to buy, if somebody buys a car or takes out another loan while they're in escrow, they no longer qualify. So is that kind of like a tricky way somebody could get out of escrow? Would they still keep their deposit or would they lose it?
Say that again. I'm sorry.
Let's say I'm buying a house and I'm in escrow. I waived all my contingencies, but I decide to buy a brand new car in the middle of the escrow and now I don't qualify for the loan anymore. Do I get the deposit back?
No, because you don't have a loan contingency.
So that's not a tricky way that people can get out of escrow. That's just them being stupid and losing the deposit.
Right. Yeah. Good point, Mona. If you're working with a buyer, make sure that they know not to go and make these big purchases while they're in escrow, because lenders check on that stuff. They do one last check prior to approving this loan. And if you suddenly bought a car, or you opened a line of credit at Sears so that you can get all these new appliances, that's going to show up. And if you were on the cusp of getting approved, then guess what? That goes out the door and you no longer get approved. So, please caution your buyers about that. So,
last question I have while we're just on this topic, we know you can't make big purchases, but let's say somebody is buying, like, I don't know, like they're going on a nice dinner. Could something like that ruin their chance of getting an escrow? Like, what's the maximum amount you should be spending on one purchase?
Well, no, I mean, that wouldn't do. I don't think that would do it. I mean, you're talking big purchases. You're talking big ticket items. So you're talking cars, you're talking appliances, you're talking big ticket. I mean, if you're spending $2,000 on a meal, okay, maybe that's going to do it. But
no, on a fridge. So that would be.
I'm sorry, say that again.
Like if somebody spent $2,000 on like a fridge or something.
Well, that's a big ticket item. Sure.
Yeah, what if somebody is spending a lot of money? Because I just want to make sure I understand properly enough to explain it. It's like a few $100s.
Here's Mona. I'm going to say this. Here's how you explain it. Don't go crazy. Don't go out and spend a lot of money. That's all you can say. There's not a magic number. It's just don't do it. Live like a nun and a priest while you're in escrow. Buy all your stuff after you close escrow, after you've signed the loan docs and you've funded and you've recorded. Go to town, but while you're in escrow, don't do it. That's all we can say. So, okay, moving on. Effects of cancellation of deposits. Here's the thing. Everybody thinks, oh, I've explained these conditions where if you have no contingencies, the buyer cancels and the seller gets the deposit. I say that the seller gets the deposit, but it doesn't really work that way. It's not an automatic handover to the seller. There is going to be a fight for that deposit. Trust me, I've been through it. So it is going to be a fight. So it doesn't automatically get handed over. So for one thing, escrow will most likely hold the deposit, and they will require mutual escrow instructions to release the money and where it goes. So if people can't agree on that, then it most likely will go to mediation first, then to arbitration if arbitration was initialed. But that's the process. So it's just not handed over. Final verification of contingencies. I want to point out that in all caps, not as a contingency of the sale. The final walkthrough is not a contingency of the sale, but it is an important part of the process. And what is the purpose of the final verification of the sale? It's to make sure that the house is in the same condition as it was when you first made the offer. And if any repairs were agreed to be done, that they were done. That's what it's for. Now, if the buyer doesn't want to do it, you still need them to sign a VP waiving the final verification of property. So, but it's really important. And I have all these things. Well, we'll do the sellers remaining in possession for 3 weeks, and so we'll do it before they move out. No, that's a separate agreement. This is 5 days prior to the close of escrow. If you want to do another inspection after this, prior to the seller moving out, then you do that again, whatever. That's, for one thing, that agreement's between the seller and the buyer. This happens prior to close of escrow. So, and there should be arrangements in your SIP or your RLAS. Have the seller hold back, have the escrow hold proceeds from the seller as a deposit. I don't care that they don't, this is why everything needs to be agreed to upfront. That deposit is insurance to get them out. You don't get this money until we have verification that you moved out and it's in good condition. So that's a separate agreement. This agreement, close of escrow, final VP. Repairs. If the seller agrees to do repairs, they can do the repairs themselves and give you receipts and whatnot. Or if they hire somebody, they give you that. That's acceptable. So that's right there in the RPA. Prorations of property taxes and other items. Please explain to your buyers that they are going to get a supplemental tax bill. I can't tell you how many times clients have ignored that supplemental tax bill, and then they have all these penalties tacked on. So make sure that they know, look, you're getting taxed on the seller's assessed value. It's going to take some time for the city to come up to where your tax base is. So be on the lookout for that supplemental tax bill. So brokers' compensation, you should be paid for your work. Absolutely. But be aware we are not a party to this agreement. The buyer and the seller, guys, I'm sorry, I apologize for going over, but I want to get at least to some point. We are not a party to this agreement. It's important to note. I can't tell you how many times I see commission, reducing commission or doing this and something about commission. We're not a party to this agreement. There's another agreement handling commission. Don't put in commission agreements in this agreement. And I'm stumbling because I'm going back to that example of the agent who's buying the property for themselves. That it's acceptable to put it in there because you're telling the print, because you are a principal to this purchase, and so as a principal you're saying I'm giving up my commission. That's the only acceptable space. So I just want to scope of duty. You're a real estate agent. Do the job of a real estate agent. You are not a lawyer. You should not be writing up agreements, coming up with verbiage and all of that, on this complicated things. You're not a tax advisor. You're a real estate agent, and you can advise on real estate matters. That's the scope of your expertise. Representative capacity. A lot of people buy things as an entity, as an LLC, as a trust. But there has to be somebody authorized to sign on behalf of that entity, and that's representative capacity. Trust me, on the new RPA, it's going to be much easier. The RCSD is confusing to get around, but we still have to do it for another few months. So we need that form to say this is the person who's authorized to sign on behalf of this entity. And I want to make sure that you note that it may be the seller is an LLC, or the buyer is an LLC, but things should be signed, and you have to manipulate the signatures. Things should be signed as the person who is the authorized person to sign on behalf of the LLC. I know that's a little confusing, so I'll just kind of leave it at that, and you can call me and I'll try to explain it. Joint escrow instructions. Escrow is going to take this agreement and make it out into escrow instructions. Okay, remedies for breach of contract. I've kind of touched on this. Liquidated damages. Why do we want 3%? Because if the buyer is occupying the property, if both parties sign off on liquidated damages, the limit that the seller can sue for is that 3%. If they're damaged more than that, and liquidated damages is initial, all they can get is 3%. That's why we like to see 3% as an earnest money deposit. You can't advise your clients on whether to do it or not. They need to seek their own legal advice as to whether to move forward. Dispute resolution, first step always is mediation. Then if arbitration is initial, then the next step is arbitration. What is arbitration? Arbitration is a judge or a real estate attorney who listens to the arguments on both sides, and they rule based on that, and their ruling is final. What you're doing is you're giving up your right to court. Now, arbitration, some say it's more expensive, some say it's not. My guess is probably is not. If you go to trial, trials take years to go through. Arbitration definitely is faster. Once again, we can't advise our clients on whether to initial arbitration or not. I had a case, somebody say to me actually today that in the agreement, it was initialed by the seller, but wasn't initialed by the buyer. Well, guess what? There's no agreement. If either both sides have to agree or not. So if they don't, if you're a listing agent and you saw that the buyer did not initial arbitration, counter it that buyer to initial arbitration. If they don't want arbitration, then that forces the other side to come back and say arbitration is not a part of this agreement. Then the seller has, the ball is back in the seller's court as to whether they want to arbitration or not. It's as simple as that. So there are some exclusions from having to go to mediation or arbitration, and that is the agreement does allow parties to go to small claims court. Like in the case of a final verification of property, if the seller agreed to do these repairs and they weren't done, then the buyer can take them to small claims court as a remedy and sue them in small claims court for the cost of doing that. So that's one. And also there's an exemption of probate also. So, okay, selection of services. This says that we're going to recommend some services like escrow or title or all of that, or even an inspector, but we don't guarantee the performance of anybody we suggest. That's in here. Another, attorney's fees. Usually the prevailing party gets attorney's fees, but if you don't mediate, you don't get to sue for attorney's fees. So that's that's something that you should know. Assignment. You know, a lot of times corporations want to assign to an LLC or Mona, I have to get through this. I'm running too late. I'm running out of time. See if you can type it up in the chat, and maybe I can do it. Buyers want, the corporations, they want to you know, change the buyer to a corporation. Okay, the seller has to agree to that. You can't just assign it to another party. The seller's agreeing to sell their property to this person or entity, and if they don't, if the seller doesn't agree, it doesn't get assigned. So that's important. And there's another form, the AOAA, that is to add a buyer. Say you have to add a buyer. You have to delete a buyer. That's all done on that form AOAA. Equal housing opportunity. We cannot discriminate between amongst those protected classes. That's very important. Seller, seller says, I don't want to sell to this person, and if they are part of one of those protected classes, we have to say, I'm sorry, Mr. Seller, we can only base our, the decision on the financial terms of whether this person, when this person, whether they can buy it or not. You can't discriminate. Terms and conditions of the offer. Time is of the essence. That means, hey, Mr. Buyer, you have certain things that you have to do in a timely manner. Make sure that there are consequences to not meeting those deadlines. The seller can give you a notice to perform, and he can cancel. Definitions, that's pretty self-explanatory. This offer has an expiration. It's defaulted at 3 days at 5 o'clock on the third day. So if you want to change that, change that either being personally received by the buyer or most likely the buyer's agent. So, and then the buyer signs, and then the seller, the next page is the acceptance. Now the seller can accept this as it is. Or they can accept it subject to whatever counter offer, which is most likely the case. But here's the thing. It's only accepted upon the confirmation of acceptance. Now, and that confirmation is sent to either the buyer or to the buyer's agent. Now, it's not required that the listing agent initial this as the confirmation. It's strongly suggested so that there is no question, and a listing agent can't drag their feet and not confirm the acceptance. Most likely, if you've sent it, it's been accepted. There are some arguments, but in order for there not to be any kind of vague or argument made, just listing agents accept the offer, initial it, and send it back. And here's another thing. If you're countering, I know it's a pain, if you're countering a number of offers, have the seller sign the original offer and then send your counter offers. Not all counter offers have to be the same, by the way, to all the buyers, but have them sign the original offer. Because you can have some sellers that say, well, I never signed the original one, so we don't have a deal and I don't owe you any money. And just so that everything is done, have them sign it first. Here's where the agent's information goes. I want to point out that presentation of offer pursuant to standard of practice 1.7, if the buyer broker makes a written request, seller's broker shall confirm in writing that this offer has been presented to the seller. What does that mean? If I, as the buyer's agent, send you an email saying, did you present my client's offer? And I send you an email back saying, yes, the offer was presented, that's sufficient. We do not require initials of the presentation. It's not required. We do not require an initial of the seller rejecting the offer. Is it a good practice? Absolutely. Absolutely. If somebody wants proof that their offer was, if indeed the seller has rejected somebody's offer, just send them the page and have them initial the rejection. So that is the RPA. I've taken up enough of your time. Mona, when would somebody sue for liquidated damages? Somebody would sue for liquidated damages if they, for the deposit, if they canceled, then if somebody, if the seller wants the deposit, they have to sue for the deposit, and the deposit, if liquidated damages is initial, that's the damage, the 3%. So I'm sorry. You're welcome. You're welcome. I hope it was informative, and like I said, next Wednesday I'm doing a class on disclosures. I promise I won't go over an hour because it's not as complex. So everybody have a good day and stay safe. And I'm going to just stop my sharing. Stay safe and happy selling. All right.